people want to know, how is it that the Senate is allowed to decide the constitutionality of something as opposed to having to go to the Supreme Court? Essentially, the Senate yesterday voted it was constitutional to proceed with impeachment. And Bill Cassidy, Republican senator from Louisiana, voted with the Democrats. And a lot of Republicans are mad at Cassidy for doing it. But Cassidy's principal point is he's not in favor of impeachment. He'll vote against impeachment. But it is constitutional because the Senate has done this before. There actually have been situations where the Senate has had a trial for the impeachment of someone, not a president, mind you, but I think it was a cabinet secretary who resigned, but was impeached before the resignation, and the Senate continued to carry on the trial of impeachment even though that person was gone. And he voted yes, it's constitutional. He's got a prerogative he's got an obligation to protect the Senate. But a lot of people are emailing me and more than a dozen on Instagram and Twitter sending me direct messages saying, how can they do this? The Supreme Court's the arbiter of constitutionality. And I guess the reason I'm shocked is because it's conservatives asking me this question. You know, punting to the Supreme Court to determine the constitutionality of an issue is actually a modern construct of the late 20th century. Up until the late 20th century, the president and Congress, both houses of Congress independently, believed they had an obligation to determine constitutionality of issues. And in fact, the Supreme Court would not, in some cases, take cases if Congress had not made a determination of constitutionality. There are rare cases where that has happened. You know, when George Washington was president, the only time he vetoed anything was on constitutional grounds. In fact, historically, the first number of presidents, their vetoes were based on constitutionality grounds, not on partisan philosophical policy objectives. So overwhelmingly, their determinations were based on constitutionality. It is a very modern late 20th century idea that the Supreme Court is the sole arbiter of constitutionalism. If you read the Federalist Papers and you read the structure of read into the structure of the Constitution, what you see is that every single branch of government has an obligation to assess constitutionality. Specifically with impeachment, the Supreme Court in the 1970s had a series of rulings, one of which was authored by then Associate Justice William Rehnquist, who would go on in the Reagan administration to become Chief Justice. And Rehnquist made it very clear that impeachment is a political process. And he wrote in the opinion that in matters that are purely political, the court itself cannot play a role, and each branch of government must determine the constitutionality of the matter. And only when the matter moves beyond the political into the realm of judicial and due process can the court get involved. So, for example, if the Senate, in its trial, forgoes due process, then the court can get involved and say, you've got to give due process. But impeachment itself is a purely political matter. And so the court can only get involved if the Senate itself violates the rules of the Senate. And then all the court can do is force the Senate to follow its rules.